Hello everyone, welcome to week 4 of administrative law. This week we'll be talking about merits review, which is a specialised form of reviewing an administrative decision that stays within the executive limb of government. So broadly, when we're thinking about the design of this course and the sort of roadmap that we're taking, last week we talked about the ways in which we can access information, either specifically the reasons for a particular decision or freedom to access all kinds of government information. And from there, we find ourselves in a little bit of a crossroads in terms of challenging or reviewing an administrative decision, whether we go down the merits review pathway or the judicial review pathway. So in this week, we're talking about merits review, and I'll begin with a fairly detailed comparison of the two forms of review. And then we'll spend the rest of the video talking about what merits review is, the kinds of decisions that can be reviewed under merits review, and the process and the sort of the procedure for doing so. So we'll start off by talking about what is merits review. We'll talk about the Administrative Appeals Tribunal, which is sort of the peak body or institution for merits review at the Commonwealth level. We'll talk about the scope of merits review at the AAT, the kinds of decisions they can review, and then we'll talk about standing, procedure, and evidence within merits review. So let's start with a bit of a comparison between judicial and merits review. Judicial review is what we traditionally think of when we think about the role of the courts in reviewing administrative decisions, and I guess the origin or the source of that legal authority comes from common law and the sort of sovereign power that is invested in the judiciary. It takes place in courts, and really we're focused on the legality of the decision rather than the decision itself. So we're interested in did the lawmaker follow the law, follow the requirements of a particular piece of legislation in making that decision. We're not too concerned with what the actual decision is. We just want to know, was it arrived at in a proper way? What we mean by that then is that we're not concerned with problems in relation to facts or unfavourable exercises of discretion with the decision. We're interested in the process itself. It can be quite slow and expensive because that's the way the courts work. And traditionally we get lawyers involved because it is a complex and very formalised process. Merits review was introduced somewhat controversially as an alternate pathway to reviewing a decision without needing to go through the slow, expensive, very formalised judicial process. And so merits review, its source is legislation, and we'll look at some of the pieces of legislation that create merits review in a moment. But because it is based in legislation, there's no sort of universal form. We'll talk about the typical form, which is merits review in a tribunal, but there are a myriad ways of performing merits review. As I've said, the merits review stays within the executive. So it's, say for example, the Administrative Appeals Tribunal is an institution that's situated within the executive government, not within the judiciary, and that impacts the way that it goes about its review of a decision. But one of the advantages of that is that it's not restricted to pure legal questions. Instead, its scope is broader, and we can look at facts and discretion as well as questions of law. So where in judicial review, we're interested in, was the law followed or not? In merits review, we're interested in, was the correct and preferable decision reached? Which means that the scope for review is bigger. We can look at, problems with findings of fact. We can look at whether a better decision could be reached. It tends to be less formal as well, which means that merits review can be cheaper and quicker, although as we get into some of the more formalized tribunals like the AAT, there still can be some significant costs associated with that. Another thing that's really interesting about merits review, because it's not so tied to the judicial process, is that there is scope for it to include other professions rather than just lawyers. And in particular, doctors, social workers, experts in particular fields like urban planning or architecture can also be really usefully involved within the merits review system. It's not, because it's not just a legal process, we don't need just lawyers to be involved. So that's a brief comparison between the two. And if you want a really simple one sentence summary of the distinction between the two, merits review is a review of the entire decision on its merits. Judicial review is purely focused on the procedure and the process by which the decision was reached. So to put that another way, generally speaking, judicial review focuses only on questions of law, whereas merits review is broader. It can look at questions of law as well, but it is also open to look at questions of fact and maybe policy as well at times. So what do we mean by that? What's a question of law versus a question of fact? To give you a really simplistic example of a general statutory power, most bits of administrative regulation can be boiled down to a simple formula. If X exists, Y shall or must or can or will do Z. So if something exists, a decision maker can, should, must do Z. The question of fact in that sort of formula is, does X exist, right? That's a matter of a factual, it needs to be factually determined whether X exists. The question of law relates to, well, what does X mean? What's the definition of X? What does Y mean? Who is Y? Who's authorized to make this decision? And what does Z mean? What's the thing that they can do, should do, must do, whatever. So to give you a more concrete example, if the director of animal control determines that a dog is dangerous, then the director shall issue a control order. So the question of fact here, X, is the dog dangerous or not? Based on fact, is this a dangerous dog? And I've given you a picture of my dog Daisy here, who is definitely not a dangerous dog. She's generally very placid and timid, unless you try and wake her up from a nap, in which case she does get a little bit grouchy. The question of law in this scenario is, did the director of animal control issue a control order in relation to that dangerous dog? So did they follow the correct legal procedures? Did the control order take the form in which it was intended to take? Was it issued in the right way? Was the owner of the dangerous dog given the right notice? All those sorts of things are legal questions. But they're based on a question of fact, which is this dog dangerous or not? Now, that's quite a simplistic example, and we'll have a look in some later weeks about some rare exceptions where a court can look at a question of fact. But for the moment, let's just keep things simple, and we'll consider that courts or the judicial review is only concerned with questions of law. So was the proper procedure and process followed? Merits review can look at questions of fact. So if a decision maker, the director of animal control says, yep, this dog is dangerous, I'm making a control order, the question of law that the judicial process and judicial review is interested in is, was that control order followed correctly? Was it issued correctly? All that sort of stuff. They can't look at the determination that the dog is in fact dangerous. Under merits review, where questions of fact are open to discussion and challenge, a merits review tribunal can look at that question of fact and say, actually, based on the evidence, we don't think this dog is actually dangerous. So that's a simplistic, I guess, example of the difference between the two. Judicial review, questions of law only. Merits review, questions of fact as well. So which facts can be reviewed? Because not every single fact is open for a discussion and debate. And really, it's hard to give an all-encompassing answer because, like I said, merits review takes its authority from particular pieces of legislation. And so it will depend on the particular piece of legislation which facts are open to review and which facts can be used in a merits review. As a general basis, the facts that were before the decision maker at the time of the decision will almost always be reviewable. So the information that the decision maker had at hand, most of the time that will be open for merits review. And if you were unhappy with the decision that was made, you could ask for merits review and you could argue that based on the facts that were available at the time. Under some circumstances, we can introduce new or fresh evidence that wasn't before the decision maker at the time. This is called a de novo hearing. And so not all hearings or not all merits review is allowed to be heard de novo, but when that is available, that means that new or fresh evidence that wasn't in front of the decision maker at the time can be introduced, and that can obviously have a massive impact on the final determination or the final decision that comes out of that review. Now, if you have a think about access to information, which we talked about last week, accessing reasons for decision, but especially accessing government documents via freedom of information, that could be a really useful way of finding fresh information that you could then use in a de novo hearing. So you can see already how we're starting to layer these weeks on top of one another. Last week, we talked about how you might go about accessing government documents via a freedom of information application and the kinds of documents you might be able to obtain. This week, thinking about a merits review, thinking about the questions of fact that can be reviewed, we might be able to review the decision and introduce new evidence based on the freedom of information application that would have gone ahead. But you can only do that if the legislation permitting merits review allows for a de novo hearing. Let's take a step back now and talk about the Administrative Appeals Tribunal, which is sort of the main merits review body that we think about when we're talking about Commonwealth administrative law. So I guess some brief key characteristics about the AAT. It's established under the Administrative Appeals Tribunal Act of 1975. And so most of the things that we're going to be talking about for the remainder of this video will be references to the AAT Act. What's interesting about the AAT is that it, as I've said, is firmly within the executive. It's not a court. And for those of you who have studied constitutional law, you'll know that this distinction is really important under Chapter 3 of the Constitution and thinking about courts which are vested with the Australian government's judicial power. The AAT does not have judicial power. It's not a Chapter 3 court. It doesn't fit those requirements. It doesn't have membership for life and things like that. So that's quite important because the actual process itself of the AAT is very court-like. It has a lot of the similar sorts of processes. A lot of the members of the AAT are judges, but they're not obviously acting in quite that same judicial capacity. There's still very formalized rules of evidence, although there is flexibility to not have to follow all the usual rules of evidence. And so the AAT itself is very court-like, but it's not a court. And that's really relevant because it allows the AAT to undergo merits review and hear merits review cases. There is some question mark over the AAT's independence. It generally has a fair degree of independence, even though it is part of the executive. But of course, it does still rely on funding from the Commonwealth Government, membership is appointed by the government. So there are, and membership is not for life, it's only for 7 years in most instances. So there are some question marks about whether the AAT is as independent as we would like it to be. It's certainly not quite as independent as a court, but that's a trade-off that has to be made in order to keep it within the executive, in order to empower it to undergo merits review. So, it's probably about as independent as we could get it while still staying in the executive branch, but it does still, of course, have some limitations. Merits review in the AAT is provided for under Section 43 of the AAT Act, which allows the tribunal, while reviewing a decision, to exercise all the powers and discretions that are conferred by a relevant enactment on the person who made the decision. So, in other words, the AAT steps into the shoes of the decision maker to look at the decision that was made and remake it if need be. So you'll see the sub-points under Section 43 empowers the AAT to affirm the decision that was under review, vary it, or completely set it aside and make a new decision, or send it back to the decision maker to remake the decision. So there's a lot of options there for the AAT to completely remake the decision, affirm it, or to just make a minor variation based on the needs of the case. So how does the AAT make its decision? How does it decide when it should accept the decision or when it should vary it or set it aside and make a new decision? And really the function of the AAT is to try and reach the correct and preferable decision. And that comes to us from Drake and the Minister for Immigration and Ethnic Affairs. Chief Justice Bowen and Justice Dean said that the question for determination by the tribunal is whether that decision was the correct or preferable one on the material before the tribunal. So material before the tribunal, not material before the original decision maker. So usually if the empowering legislation says that the AAT can be heard de novo, then you can introduce new and fresh evidence. You're not limited to evidence that was before the original decision maker. And then based on all that evidence, the tribunal has to try and reach the correct and preferable decision. So correct being correct at law. So ensuring that all the correct procedures are followed, which is that the question of law, which the AAT can look at, but then also the preferable one. Have the questions of fact been resolved in the preferable or best way? And that gives the AAT a large scope to try and decide how a particular matter should be decided. It also means that for citizens who are challenging an administrative decision, there's a lot of scope to make a really compelling argument that this would be a better decision than the one that was made originally. The one that was made originally is not the preferable decision. This one is better, and you set out your reasons why that is the case. And it might be that there is fresh evidence that has come to light, or it might be that the original decision maker ignored the evidence that was in front of them to begin with. So to sort of hone in on the scope of the AAT's review, they review the actual decision. So you have to already have had a decision made in order to review it. You're not trying to jump in and preempt. If you thought the decision maker was going to make a decision that you weren't happy with, you can't jump in and preempt that. You have to wait until the decision has been made before you can start review under the AAT. And the AAT can review legally invalid decisions. So decisions that are invalid because of an error of law, which is what judicial review handles as well. But we're also interested in the AAT's ability to provide merits review as well. An applicant must have standing under Section 27 of the AAT Act. So that's, their interests have to be affected in some way. It can't just be some random person off the street challenging the decision. The applicant has to have some material interest in the decision that was made. You've got 28 days to make an application to the AAT for review. That's provided for under Section 29. Usually the AAT will be quite adversarial. So the applicant on one side, the decision maker on the other, are arguing about whose version of events is the correct and preferable decision. But the AAT does also have some scope to be a bit more inquisitorial. So in addition to evidence introduced by the two parties, the AAT sometimes is empowered to go out and find its own evidence or commission its own expert reports and things like that as well, which is obviously quite different to the way that courts operate, which are purely adversarial. So this is a good example of the way that there is a bit of flexibility in what the AAT can do. They're also not bound strictly by the rules of evidence. So things like hearsay, things like personal opinion from people who are not experts, there is a bit of flexibility to allow things like that. Whereas under a judicial review process, those things wouldn't be allowed. Now, the AAT does sort of, apply these things with a bit of skepticism, and it is a bit cautious about things like hearsay, because there are quite good reasons why that type of evidence is excluded from the judicial process. But there is flexibility, there's a bit more informality, and certainly in the way that the AAT functions procedurally, the way that it goes about conducting a trial or a hearing, it is a lot more informal than a judicial process in a courtroom. So that's merits review. Next week, we'll be coming back to talk about judicial review and some of the foundations of judicial review. So I look forward to seeing you then. Thanks very much.